Hello, and welcome to Mullen's Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Brydon DeWitt. At the very end of 2022, actually on December 29th, 2022, President Biden signed the long-awaited Secure Act 2.0. This highly anticipated legislation makes a long laundry list of changes to qualified retirement plans, 403 and 403B plans. And today I'm going to review some of the highlights of the new law. I'm not going to hit everything in the new law. And I thought it would be helpful to address the items in the Secure Act 2.0 that are effective this year. So there are several items that are effective right now as we speak. And then there are other provisions that take effect in 2024, 2025, and 2026. So on today's podcast, I'm going to focus on just some of the highlights, or at least things that I think are highlights that are effective in 2023, and then some of the ones that are upcoming in 2024. And as a reminder, as with the Secure Act 1.0, the amendment deadline for Secure Act changes is the last day of the plan year beginning on or after January 1, 2025. So there's a lot of time to get plan documents up to speed with changes with the first Secure Act and then the second series of legislation known as the Secure Act 2.0. But there's a lot involved with this legislation, and I think it's advisable for clients to start amending their plans along the way because it may be difficult to remember exactly what we did in 2023 when the plan is being amended, and maybe in December of 2025. So with that, again, I'm going to start with some of the items that I think are highlights that are effective now in 2023. And a lot of these changes in the Secure Act really are providing participants more flexibility with getting money from their plans and also geared toward encouraging employees to participate in qualified retirement plans. So the first one in 2023, as of right now, up to $22,000 may be distributed from a retirement plan to individuals affected by a federally declared disaster. So again, this is giving participants more flexibility to get money out of their plans before they separate from service or retire. The original Secure Act increased the required beginning date, the mandatory distribution date, from retirement plans from age 70 and a half to age 72. The Secure Act 2.0 further increases that from age 72 to age 73. So under Secure Act 2.0, participants may leave money in their plans just a little bit longer than even the extension in Secure Act 1.0. Additionally, plans may allow penalty-free distributions for individuals with a terminal illness. And so what this means is if an individual has a terminal illness, they can take money from their 401k plan early before they reach age 59 and a half and not be subject to the early distribution 10% excise tax. In the original Secure Act 1.0, there's a provision that allowed plans to permit participants to take distributions for qualified birth and adoption. And those distributions may be repaid back to the retirement plan or treated as kind of as a rollover back into a qualified retirement plan. The Secure Act 2.0 limits the repayment period for qualified birth and adoption distributions to 3 years from the date of the distribution. Participants may elect to treat employer matching or non-elective contributions as Roth contributions. So a Roth contribution is made to a plan on an after-tax basis. So participants, currently plans may allow elective deferrals, such as 401k deferrals, to be treated as Roth elective deferrals and taxed or made on an after-tax basis. And now participants have the flexibility to treat employer non-elective contributions and matching contributions also as after-tax. So the participants will pay taxes now, and then those amounts and the earnings on them would come out tax-free at retirement. The Secure Act also makes it a little bit easier on plan administrators to administer the plans. There is now no longer a need for a retirement plan administrator to seek recovery of overpayments to retirees. So sometimes through an administrative error, a retiree will receive more money from the plan than the plan document provides. And under the correction principles in effect prior to the Secure Act 2.0, one of the things plan administrators needed to do was try to seek the recovery of those overpayments from the retirees, which often was not very successful. So the Secure Act 2.0 eases that burden on plan administrators. They no longer have the requirement to seek the recovery of overpayments to retirees. And another way that the Secure Act 2.0 is making life easier on plan administrators is eliminating some of the notice requirements to unenrolled employees. So this is the first time that I've seen Congress make fewer notice requirements as opposed to imposing more notice requirements on employers. So under the Secure Act 2.0, if an employee is not enrolled in the plan, the employee does not have to receive all of the notices that would be otherwise required to be provided. But the employer does have to provide at least an annual reminder to employees that they are eligible to participate in the plan. So that's a kind of a laundry list of items that are effective currently. All these items I've just described are already in effect. Many of them require plan amendments. And again, those plan amendments would be due as of the last day of the plan year beginning on or after January 1, 2025. Looking ahead into 2024, there's some kind of popular provisions that have been talked about a lot in the Secure 2.0 that come into effect next year. The first has to do with student loan repayments. So under the Secure Act 2.0, student loan repayments may be treated as elective deferrals for purposes of matching contributions. So what this means is some employees, they may not be contributing into a 401k plan because they have the burden of making student loan repayments. And to allow these employees to at least start saving for retirement earlier in their employment life, they can treat their student loan repayments as if those payments were actually elected deferrals under the plan and then receive a matching contribution from the employer. So they're not putting money into the plan as an elective deferral, but they would be getting the matching contribution as if the student loan repayment was an elected deferral under the plan. Of course, this is an optional provision, and a plan amendment by the end of the 2025 plan year would be required. Additionally, the Secure Act 2.0 in 2024 will allow penalty-free withdrawals of the lesser of $10,000 or 50% of the account balance if a participant self-certifies that he or she is a victim of domestic abuse. This is another optional provision that can go into effect in 2024, where a plan would allow this distribution if the participant is a victim of domestic abuse. This is another requirement in 2024 that all catch-up contributions for employees who earn more than $145,000 per year will be treated as Roth contributions. In other words, for high-paid employees, their catch-up contributions will be treated on an after-tax basis. So those contributions will be taxed currently. The advantage to the government is the government gets its money sooner. The advantage to the employee is that when those contributions plus the earnings of those contributions are distributed at retirement, those amounts will come out tax-free. And finally, in 2024, the involuntary distribution limit will be increased from $5,000 to $7,000. So in 2024, a plan may involuntarily make a lump sum distribution if a participant's account balance is $7,000 or less, as opposed to the current $5,000 maximum. And again, this is a voluntary change that would have to be reflected in a plan amendment adopted by the end of the 2025 plan year for plans that have plan years that begin on or after January 1, 2025. And then there are some other additional provisions that I'm not going to go into today that go into effect in 2025 and a few that go into effect in 2026. Again, these are just some highlights. This is not an exhaustive list of the Secure Act provisions that go into effect in 2023 and 2024. A full list and description of the Secure Act 2.0 is available at williamsmullen.com/employee benefits. That will wrap up my discussion of the Secure Act 2.0. If you have questions or comments for future episodes of this podcast, please contact me. You can also visit our employee benefits page at williamsmullen.com/employee benefits. There you can find out more about our team as well as past episodes of this podcast and legal alerts. Finally, be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.